Hello. Very often when people come to us, to lawyers, asking questions, we repeat and repeat and repeat the very same idea that it's much better to come and see a lawyer before you sign a document, be it a contract, a will, or something like that, than to come after and to ask how do you deal with the consequences now. And one of those famous or infamous documents is a preliminary contract. A contract that you sign when you're going to buy a new condo, a condo in a newly constructed building. And as opposed to what many people think, it's not just a formality, and it's not a standard contract which is same, similar, or even identical with every other developer, with every other construction company or development company. There are differences, there are nuances that you should better know in advance, and there are things that might define your rights, obligations, and bring more or less trouble, usually more than less, after, when it's time to pay, when it's time to receive what should be duly yours, when it's time to see that something is not done well and some delays, some deadlines are missed, and when you want to change something or the constructor wants to change some materials or whatever else, or when you want your money back, for example. And if you do not pay attention to that in advance, you might see unpleasant surprises later. So the first thing, and the first thing we will be reviewing in such a video, is what do you expect to see in the contract and what you should verify in the contract, in a preliminary contract. First of all, the space itself. How many square meters, how many square feet are you expecting to have there? Because it might be net space, or it might be space including walls and outer places like balconies. And later, when you just come and see, if you did not pay attention to that, you might be disappointed, but it will be a little bit late then. Then, because it's a condo, so it will be a fraction of the greater territory, greater space, the building itself. You will have to understand what will be your fraction, what will be the percentage of your fraction, because that will define your future fees and payments in comparison to those of other people, of other owners of your neighboring condos. And sometimes, again, it might be higher than you would have thought before, if you thought of that, of course, and you should have. The famous idea of 10 days for you to walk away, to think after you've got this sales meeting and you are all impressed, but then you have 10 days for cool down. And as opposed to many people think, again, it's not always free to go away. Often there is a penalty, and sometimes the penalty is significant or at least sensitive. So if you don't see it in the text, then you should ask. And if you see it in the text and you don't like what you see, you should discuss, you should negotiate, and if you're not satisfied with the result of the negotiation, you probably should go and look for something else. Because that's the beginning, but this beginning might show how pleasant or unpleasant will be the rest of the communication with the seller. Because when something is being offered to you, being advertised to you, they are nicest, as you understand. And later, if they're already rigid and let's say greedy at this point, it might be worse later. Well, usually you're cautious enough to at least ask questions about the payment methods and the schedule and what will be the sale price, but not always you ask to decompose the sale price for you, to just show you every detail of how it's added one to another. And if you miss something, then again, the final price, the actual amount of money you are paying might be even different from what you were expecting. Again, counterintuitively, and to an unpleasant surprise for many, the idea of what does it mean to complete the work for a seller is different than the idea for the buyer, because the buyer is usually expecting that the end of it will be when everything is complete, everything is livable, everything is good, and you move in, and that's the end of the story. But by the contract, it's usually not the same. And very often, if you just miss that point, the description, the criteria of what does it mean to complete the work might not benefit you, so that you would face the situation when, like, technically by the contract everything is completed and you have to pay, but in fact there are many things yet to finish, yet to come. There might be still disagreements and dissatisfaction on your side, and you might have thought that when it's complete you would just move in, and because of that you might already just end your previous lease contract, or you might already have leased out, rented out your previous condo or house or wherever you lived before. And then you will face the situation when you either have to breach your new contract or to ask for a new lease, because this new condo is not yet ready for you to come. So the preliminary contract should explain in some measurable way when exactly the work is complete and what exactly does it mean. So what will you expect after this formal date of completion? Preferably, there are some intermediate deadlines also. And again, if you have any questions, it's best to ask them before you sign a preliminary contract than after. Because when you sign something after, you can only ask, when you sign something and then you ask after, you can only ask for a favor, for a courtesy. When you ask before, you're negotiating. That's a different position, both legal and from the practical point of view. Normally, a preliminary contract would stipulate that the seller or the construction company can substitute some materials. Usually it says for similar or like no lesser quality, or with the agreement or by consent of the buyer. But very often, if there is no consent of a buyer, it might be a legally justified reason to delay and delay and delay the date of completion. And again, you will have to verify if that's the case. And also, you will have to think how important for you that the materials would be exactly what you have discussed when you were going to sign the contract. So again and again, the usual and normal way would for you would be to take the proposed text of a preliminary contract, but not to sign it on the spot. Take it, read it, go to a lawyer or to any other legal representative or legal advisor that you could have found. Usually in Quebec it's a lawyer. And when you're really sure that you understand what's in there and understand the consequences and the implications, and what will you do if something happens not as you expect. And if you're satisfied with all that, then you come back and sign. At the very least, if you have signed on the spot already, go to see a lawyer in the first couple of days, not on the 9th day, or even worse, after the 10 days cool down period, when there is almost nothing to do but to pay some fees, and very often the fees, the penalties are significant. The preliminary contract should tell you what happens if there are delays, and if the delays are caused by the seller, and what's the case when the delays are attributed to the buyer, to yourself. Also, very often that's counterintuitive, so you should verify. Then, with respect to legal hypothecs, you should know that very often the construction company, the seller, the contractor is able to just involve some subcontractors, some other construction companies even, and if they are not paid in time, they are entitled by the Civil Code of Quebec, by the legal rules, for so-called legal hypothec, meaning that the owner of the newly purchased condo, building, house, whatever, will be responsible directly, not through the seller. So you might finally obtain a title with legal hypothecs attached to it if those subcontractors are not paid. And the preliminary contract should tell you that you won't be responsible for that, and that the seller is obliged to provide the title, the property, to you free of legal hypothecs. And if not, what will happen? Will be there any kind of insurance, for example, or any kind of like money back, or what will happen if not? Because again, it's not unusual, and it's not impossible when you have duly paid what was in the contract, you received your title, and then you realize that you still owe the money for those people who are actually working on your condo or on the building altogether in some proportion, because the developer, the seller, just failed to pay them. That happens. Also, again, in our reality, there might be a situation, usually to protect the seller, when their actual company, a legal person building your condo or your house, the whole building, that company, legally speaking, is not the same that the company that sold it to you, because there might be just a split of two corporations. One is building, one usually connected to the first one, but not necessarily, has a contract with the building company, with the constructing company, and the other one is the only company created for this particular sale. So in case of any kind of bankruptcy or whatever, the seller company will disappear, but you could not go through it to the company which was actually constructing the site. And if that's the case, then again, you should see what are your guarantees. What will you do? So those are the very first questions to ask. Then, if you prefer, and you should prefer, you go deeper than that. You see, and that's usually the idea of every contract, because if everything goes as it was foreseen, as it was predicted, as it was intended, the contract is usually just a formality. You just fulfill your obligations, the other party fulfills their obligation, and that's the end of story. The real value of a contract is if something goes wrong. because then a good contract at least should tell you what to do and who is responsible for the breach of contract and to what extent. Because very often, again, or at least it's not unusual, when such a thing is not in a contract and then you think that your rights were violated and you want to go to court. And you can. And the court will most probably even protect your rights, will agree with you, but to go there, you will have to pay normally. And if the amount in question is about, let's say, 25,000 or so, and to go through the court system, you'll have to pay 25,000 or so. The other party may be in bad faith, but it's impossible to prove, usually. The other party would simply tell you, okay, you can go to court, but you will simply lose the same amount of money. So why would you even bother? And very often when you come to a lawyer at that point, the lawyer will tell you, just, do you have a right? Yes, you do. Can you go to court? Yes, you can. But commonsensically, should you, in a situation when you will spend about the same money as you're going to achieve, plus all the stress, all the just inconvenience, all the hesitation, all the hostility, and so on and so on. And even your own lawyer will tell you it's better to negotiate. And the other party would know that. So very often there is a split between real reality and legal reality to that matter. So again, it's best to see what is to go on in case of a breach of a contract, in case of default, in case when one party, well, in your case, the other party, the seller, does not fulfill their obligations. But also, if you think that it might be your case, you should review what happens if you do not fulfill your obligations, basically pay in time. And very often it might be when you're not simply satisfied at the end and you want to negotiate, but the contract tells you that right now at this point, the date of completion, you have to pay. You want to negotiate, so you miss the date, so you're in default. And then not only you lose money, but sometimes you even lose your right for the title, and the seller is free to sell it to somebody else at a higher price, which is again not unusual in our situation. So it's a very good idea to review. It's a very good idea to see what's going on. As we discussed before, if you're not really sure what is the date of delivery and how does it correspond with the date of completion of work, with the day of the end of work, and if it's a strict deadline or is it flawed, inflexible, and what happens if the seller is not able to provide in time, because very often nothing really happens. They only have to advise you that they will have to postpone the deadline. Well, that's what you can usually find in the preliminary contract. Then maybe it's not what you would expect, and maybe it's the time to ask the questions before again you sign. And if the answers are not satisfactory to you, maybe you should go and verify with somebody else. If you should even proceed with this contract. Any other term in a contract that is not clear for you, do not rely on the explanations, verbal explanations that are given on the spot by the sales representative. Because whatever they tell you verbally on the spot, of which you don't have any proof, it's not a part of a contract. What's written in there is a part of a contract. There are many situations when people with visible regret and sorrow tell me like, well, we discussed that, this is what they told us, but we cannot prove it, obviously, right away. Whatever you cannot prove, that kind of an explanation is not sufficient. So if you ask for clarification, and if they're ready to add those clarifications in writing to the contract, okay, that might be worth it. If not, first of all, it might be an incorrect explanation, or at least there might be huge omissions in the explanation because the sales representative is interested in you signing the contract. And second of all, you could not prove. So again, go to see a lawyer first, and maybe after ask some questions in writing via email or even a text message also would count as writing, and see what happens in response. We'll come back to this topic later, but at least those are the things that you should have verified from the very beginning. Thank you and have a nice day.